Good morning, good afternoon, or good evening from wherever you're watching or listening. My name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information plenty of bad folks would rather you not have. In today's lecture, we'll be providing another installation into our Anti-Federalist Papers series going on number 44. So if you haven't gone back and watched 1 through 43, I would highly encourage you to do so because understanding the Anti-Federalist Papers in addition to the Federalist Papers will provide you a very well-rounded, advantageous understanding of the U.S. Constitution, and understanding the U.S. Constitution will be absolutely necessary if you intend to combat any sort of lawfare waged against you, your loved ones, or your hard-earned property. So let's go ahead and jump on over to the Anti-Federalist Papers. You can get a copy from multiple different institutions. Go ahead and get a paper and digital copy just in case you can't access one or the other for whatever infinite number of reasons. And if you haven't done so already, go ahead and get a copy of the Federalist Papers so you can join us in comparing and contrasting the arguments for and against ratifying the U.S. Constitution. Excellent. So number 44 is titled, What Congress Can Do, What a State Cannot. So this is likely going to be discussing Article 1, Section 10. If I remember correctly, Section 10 prohibits very, 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 very few powers from the states to exercise. So this one is written by the Deliberator, appeared in the Freeman's Journal or the North American Intelligencer on February 20th, 1788. He says this. A writer in the Pennsylvania Packet under the signature of a Freeman has lately entered the lists as another champion for the proposed Constitution. Particularly, he has endeavored to show that our apprehensions of this plan of government being a consolidation of the United States into one government and not a confederacy of sovereign independent states is entirely groundless, and it must be acknowledged that he has advocated this cause with as much show of reason, perhaps, as the subject will admit. Highlight that. So incredibly important. The champions of the U.S. Constitution. Let's just highlight this entire paragraph. The champions of the U.S. Constitution said, he has endeavored to show that our apprehensions of this plan of government being a consolidation of the United States into one government and not a confederacy of sovereign independent states is entirely groundless. So the Federalists were promising, the people who supported the U.S. Constitution were promising that this new government was not building a singular country, was not building a singular state, nation state, country, nation, whatever you want to call it. It was not consolidating. It was not forming a country. You are not an American citizen if you obey the terms of the U.S. Constitution, if you obey the terms of the Articles of the Confederation. Why? Because it doesn't form a country. According to who? Crazy kooky Caleb? No, according to the very people who advocated for its implementation. And this isn't a standalone Federalist who said this overtly. The Federalists, Madison, Hamilton, Jay, the authors of the Federalist Papers, said it as well. They said, no, there's no need to worry. Madison said overtly, there seems like there are parts in this new document that appear to be national and some that appear to be federal, but ultimately it is a union, not a nation, not a country, not a state. That's what the people who favored the U.S. Constitution were saying. No, you are not an American. No, you are not a citizen of America. No, you are not a part of the country, the United States, the state, the United States, the nation of the United States. That does not exist as per the U.S. Constitution. The words states, several states, and United States are, he observes, frequently mentioned in the Constitution. They are. Despite that, the very kinds of men that the Anti-Federalist Papers warned about, went ahead and abused the legal ambiguity that is within the U.S. Constitution to convince the masses, I included. It took me some research, it took me some time to break away from that delusion, that derision. Those wicked men that the Anti-Federalists warned about were able to convince with the legal ambiguity of the U.S. Constitution the masses that there is such a thing as an American, that there is such a thing as a citizen of the United States. There isn't. Not just according to me, but according to the very people who advocated on behalf of the U.S. Constitution's implementation and ratification. You are not an American citizen. There is no such thing as an American citizen. And this is an argument that their separate sovereignty and independence cannot be endangered. Highlight that. Again, this isn't the Anti-Federalist, the Anti-Federalist saying that, not the deliberator saying that. That is the advocate of the U.S. Constitution saying, nope, the U.S. Constitution does not in any way demean or diminish the sovereignty, the nationhood of the states. He has enumerated a variety of matters which he says Congress cannot do, and which the states in their individual capacity, let me untie my tongue, must or may do, and thence infers their sovereignty and independence. In some of these, however, I apprehend he is a little mistaken. 1. Quote, Congress cannot train the militia. That's actually not true. Article 1, Section 8 says the Congress actually has to provide for the training of the militia and the arming of the militia. This is not strictly true. For by the first article, they are empowered to, See, I just need to read the Anti-Federalist paper because it's going to say what I'm going to say. For by the first article, they are empowered, quote, to provide for organizing, arming, and disciplining them. And though the respective states are said to have the authority of training the militia, it must be, quote, according to the discipline prescribed by Congress. Exactly. In this business, therefore, they will be no other than subalterns under Congress to execute their orders, which, if they shall neglect to do, Congress will have constitutional powers to provide for by any other means they shall think proper. They shall have power to declare what description of persons shall compose the militia, to appoint the stated times and places for exercising them, to compel personal attendance, whether when can be called for into actual service, or on other occasions, under what penalties they shall think proper, without regard to scruples of conscience or any other consideration. Their executive officer may march and countermarch them from one extremity of the state to the other, and all this without so much as consulting the legislature of the particular states to which they belong. Where then is that boasted security against the annihilation of the state governments arising from, quote, the powerful military support they will have from their militia? Second, quote, Congress cannot enact laws for the inspection of the produce of the country. Neither is this strictly true. Their power, quote, to regulate commerce with foreign nations and among the several states, and to make all laws which shall be necessary and proper for carrying this power, among others vested in them by the Constitution, into execution, most certainly extends to the enacting of inspection laws. The particular states may indeed propose such laws to them, but it is expressly declared in the first article that, quote, all such laws shall be subject to the revision and control of the Congress. Precisely. Please go watch the Federalist Papers series, because Madison and Hamilton both spoke directly to the necessary and proper clause. And you know what they said? They did not echo the sentiments of the Supreme Court when the Supreme Court says, oh, well, yes, necessary and proper involves any and all things that will provide for the general welfare of the nation. No, Madison, the father of the U.S. Constitution, Hamilton, probably, he couldn't honestly be labeled the most centralist, but he was probably the most popular centralist, the one that you could quickly reference and is a household name. Hamilton, Madison, both said necessary and proper does not give a carte blanche permission slip to Congress to enact any and all laws that they think will benefit the citizens of the states. Madison and Hamilton both said necessary and proper means under the Constitution, pursuant to the U.S. Constitution. So no, you do not get to go, U.S. Congress, U.S. Supreme Court, U.S. Executive. You do not get to go outside the confines of the U.S. Constitution to provide for the supposed general welfare of the citizens of the states. You do not get to do that. That is not what the necessary and proper clause is, despite what the U.S. Supreme Court has ruled time and time again for it to mean. That is not what the necessary and proper clause means. Madison said to this, I don't think Hamilton said it explicitly, but Madison said to this, for if you allow the federal government to define their own confines, the scope of their powers, it will have infinite powers. Madison gave a very clear solution for when the federal government goes about doing that, which I'm sure those viewing who are in favor of the federal government would not like to hear. He basically said, whenever that comes about, one, the state legislatures are to be a guard against federal encroachments, and if that doesn't work, the citizens are duty-bound, obligated to take up arms. He said that verbatim. So if you're going to say a call to arms in modern context is insurrection, is sedition, is treason, then you have to be willing to call the father of the U.S. Constitution seditious, an insurrectionist, a traitor, because that's exactly what he said. Moving on. I digress. I apologize. It's so frustrating to not to read through these, but to read through these and know that the people in 1787 were warned of the horrific, atrocious government that this new constitution was going to be formulating, and they still didn't listen. The Anti-Federalists won the argument, but the implementation of the U.S. Constitution not constriction. The U.S. Constitution still took place. And we know for a fact that they won the argument because only 39 of the 70 delegates at the Philadelphia Convention voted to ratify the U.S. Constitution. If you're not familiar, please go watch the Articles of the Confederation lecture, as it explains how the second to last paragraph, if I remember correctly, required unanimous agreement to amend, let alone completely replace, the Articles of the Confederation. Even if you want to give the 9 out of 13 states voted to ratify the U.S. Constitution argument, that is still not unanimous agreement. The U.S. Constitution was never ratified. It was imposed. It was implemented. It was instituted, never ratified, never consented to. I digress again. My apologies. Third, quote, the several states can prohibit or impose duties on the importation of slaves into their own ports. Nay, not even this can they do, quote, without the consent of Congress, as is expressly declared in the close of the first article. The duty which Congress may, and it is probable will lay on the importation of taxes, will form a branch of their revenue. But this impost, as well as all others, quote, must be uniform throughout the United States. Congress, therefore, cannot consent that one state should impose an additional duty on this article of commerce unless all other states should do the same, and it is not very likely that some of the states will ever ask this favor. Fourth, quote, Congress cannot interfere with the opening of rivers and canals, the making or regulation of roads except post roads, building bridges, erecting ferries, building lighthouses, etc. In one case, which may very frequently happen, this proposition also fails. For if the river, canal, road, bridge, ferry, etc. be common to two states, or a matter in which they may be both concerned, and consequently must both concur, then the interference and consent of Congress becomes absolutely necessary, since it is declared in the Constitution that, quote, no state shall, without the consent of Congress, enter into any agreement or compact with another state. Fifth, quote, the elections of the President, Vice President, Senators, and Representatives are exclusively in the hands of the states, even as to filling vacancies. This, and one important part, is not true. For by the second article, quote, in case of the removal of the President from office, or of his death, resignation, or inability to discharge the duties of the said office, the same shall devolve on the Vice President, and the Congress may by law provide for the case of removal, death, etc., both of the President and Vice President, declaring what officer shall then act as President, and such officer shall act accordingly until the disability be removed, or a President shall be elected. But wait, I thought we needed an amendment for when Kennedy was assassinated. I thought we needed an amendment to determine the succession of power and authority. Nope. The people who wrote the U.S. Constitution back in 1787 had already provided for that. What they didn't provide for is something I explained in that amendment. Please go watch the U.S. Constitution Amendments series, lecture series. It will greatly be to your benefit. Not only so that way you can really see the fruition of all these warnings that the Anti-Federalists are giving, but also so you know the modern context of exactly what laws the U.S. government pretends to follow. But no such election is provided for by the Constitution till the return of the periodical election at the expiration of the 4 years for which the former president was chosen. And thus may the great powers of the Supreme Magistrate of the United States be exercised for years together by a man who perhaps never had one vote of the people for any office of government in his life. That's a great critique. That is a great concern. What if the president does get assassinated? What if the president just dies from old age? Natural causes. An act of God. Do the people elect the next executive? Nope. He's appointed. And he gets to continue at the tenure until the next election cycle. That's a very fair, legitimate concern. Critique of the U.S. Constitution. Sixth, quote, Congress cannot interfere with the Constitution of any state. Again, that's the Federalist. We just had a case. I mean, we have cases daily from the U.S. Supreme Court where they virtually nullify the state constitutions. But we had a case just recently, I think it was in 2023, where Missouri was looking to virtually nullify all gun laws. And I say all gun laws because saying all unconstitutional gun laws is redundant. All gun laws from the federal government are unconstitutional. Missouri combated that and said they're not going to enforce federal gun-related laws, gun-related restrictions, and the Supreme Court refused to uphold that. They didn't even hear the case. It's ridiculous. But hey, according to this Federalist, you don't have to worry about that. Congress cannot interfere with the Constitution of any state. Thank goodness that never came about. That never came to fruition. Never had to worry about that. This is what the Anti-Federalists responds with. And this has been often said, but alas, with how little truth, since it is declared in the 6th article that, quote, this Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties, etc., shall be the supreme law of the land, and every state shall be bound thereby, anything in the Constitution or laws of any state, to the contrary notwithstanding. Now we know for a fact that the Supremacy Clause, that Article 6, does not nullify the state constitutions and the state's sovereign right to nullify federal action. How do we know that? By crazy Caleb's conjurations? No, because the father of the U.S. Constitution, James Madison, let's see, when would that be? Maybe a decade later, in 1798, with the Virginia and Kentucky resolutions, wrote a state's proposition to nullify federal action. And if you're going to say, well, that's just the opinion of one man, if you're going to toss out the principles and the practices of the person who was basically the center of the U.S. Constitution, then reason has left you. Point being, Madison, in the Federalist Papers, said no. In fact, the states retain their sovereignty. No. In fact, the states keep their power to nullify federal actions because the federal government, the union in total, was formed for the state's benefit, not vice versa. So if the union is no longer benefiting the state has no reason to, 1, stay, or 2, obey. And he practiced what he preached in 1798 when he drafted the Virginia resolutions, which declared nullification of certain federal actions. If you haven't watched that lecture, go ahead and go watch that one. Now, that one, the lecture is focused mainly on Thomas Jefferson's writing of the Kentucky resolutions of 1798, but you are more than welcome. In fact, you are encouraged. I implore you, please go read the Virginia resolutions of 1798. They're authored by James Madison. He says basically verbatim what Jefferson argued in the Kentucky resolutions of 1798. So here's what the Anti-Federalists said in response. But, sir, in order to form a proper judgment of the probable effects of this plan of general government on the sovereignties of the several states, it is necessary also to take a view of what Congress may, constitutionally, do and of what the states may not do. This matter, however, the above writer has thought proper to pass over in silence. I would therefore beg leave in some measure to supply this omission, and if in anything I should appear to be mistaken, I hope he will take the same liberty with me that I have done with him. He will correct my mistake. 1. Congress may, even in time of peace, raise an army of 100,000 men, whom they may canton through the several states, and belay out on the inhabitants in order to serve as necessary instruments in executing their decrees. What happens? Let's see. 1795, I think, was when the Risky Rebellion was. Less than a decade after the implementation of the U.S. Constitution. Excuse me, good grief. What happens less than a decade after the ratification of, well, not ratification, after the imposition of the U.S. Constitution? George Washington, the man of the purest heart, sends 10,000 troops, 10,000 soldiers to Pennsylvania to compel, at gunpoint, 500 Pennsylvanians to pay an unrepresentative, abusive, unconstitutional tax. And we know for a fact that Washington knew it was the incorrect thing to do because he pardoned every single individual involved in the matter. Not the troops, the Pennsylvanians. And if Washington couldn't resist the allure of tyranny, the allure of artillery as a tyrant, no one else could. That was the whole crux of Hamilton's argument as to why the executive should have so much power, because Washington, the very first person we're going to trust with it, is going to demonstrate how to use it, and everyone else after that will follow his example. No. He was such a liar. Not necessarily Washington. I do think his writings, his orations made evident that he recognized his mistake and regretted it in his latter days. But Hamilton, all of his pennings, his orations, he was just an arrogant, malicious actor. Number 2, upon the inhabitants of any state proving refractory to the will of Congress, or upon any other pretense whatsoever, Congress can out even all the militia of as many states as they think proper, and keep them in actual service without pay, as long as they please, subject to the utmost rigor of military discipline, corporal punishment, and death itself not excepted. 3. Congress may levy and collect a capitation or poll tax to what amount they shall think proper, of which the poorest taxable in the state must pay as much as the richest. 4. Congress may, under the sanction of that clause in the Constitution which empowers them to regulate commerce, authorize the importation of slaves, even into those states where this iniquitous trade is or may be prohibited by their laws or constitutions. 5. Congress may, under the sanction of that clause which empowers them to lay and collect duties, as distinct from imposts and excises, impose so heavy a stamp duty on newspapers and other periodical publications as shall effectually prevent all necessary information to the people through these useful channels of intelligence. That's a fair point. That's a fairly nuanced point. 6. Congress may, by imposing a duty on foreigners coming into the country, check the progress of its population, and after a few years they may prohibit altogether not only the immigration of foreigners into our country, but also that of our own citizens to any other country. 7. Congress may withhold, as long as they think proper, all information respecting their proceedings from the people. Madison spoke to that one directly. He said, nope, proceedings all need to be made public and in layman's terms, so that way the people, the citizens of the states, could understand exactly what the federal government was up to and what it planned to enact. That was directly stated in the Articles of the Confederation. It was a procedural requirement, if I remember correctly. Hey, that gives you a reason to go watch the Articles of the Confederation and then come back here and tell me if I'm wrong or right. 8. Congress may order the elections for members of their own body in the several states to be held at what times and what places and in what manner they shall think proper. Thus, in Pennsylvania, they may order the elections to be held in the middle of winter at the city of Philadelphia, by which means the inhabitants of 9/10 of the state will be effectually, though constitutionally, deprived of the exercise of their right of suffrage. 9. Congress may, in their courts of judicature, abolish trial by jury in civil cases altogether, and even in criminal cases trial by a jury of the vicinage is not secured by the Constitution. A crime committed at Fort Pitt may be tried by a jury of the citizens of Philadelphia. 10. Congress may, if they shall think it for the general welfare, establish an uniformity in religion throughout the United States. Such establishments have been thought necessary and have accordingly taken place in almost all the other countries in the world, and will no doubt be thought equally necessary in this. Now, this point you may think, oh, well, that prediction didn't come true. Are you so sure? Are you so certain? Can you confidently distinguish between education and religion? Can you confidently distinguish between teaching any subject that is not codified reality, such as, well, I won't give anecdotal examples of that, but are you able to confidently, especially in the modern context, discern between what's being taught in governmentally funded schools and that of a church, that of a mosque. Not necessarily the doctrines, but the foundations of those lessons, of those subjects, of those topics being taught. I wouldn't be able to. I couldn't say for certain that public education, that governmentally funded schools aren't teaching religious subjects, aren't teaching subjects that may or may not be thoroughly founded in reality. So you can say, oh, the US doesn't fund churches, which is partly true, but it does fund schools. And you're lambasted, harpooned, and chastised if you don't partake in that system. You are imprisoned if you don't subsidize that system. 11. Well, imprisoned, you are certainly persecuted. You will have lawfare conducted against you. And if you know what you're doing, you'll win the battle. You'll win the war. You'll win against the lawfare. That's only if you know what you're doing. And they've made it intentionally complex and complicated. That way the odds are greatly stacked against your favor. But if you continue studying with the Calhoun School of Law, I guarantee you, we will get you the tools and necessary information to win that lawfare. 11. Though I believe it is not generally so understood, yet certain it is, that Congress may emit paper money and even make it a legal tender throughout the United States, and what is still worse, may, after it shall have depreciated in the hands of the people, call it in by taxes at any rate of depreciation. Gosh, doesn't that sound familiar? Compared with gold and silver, which they may think proper. For though no state can emit bills of credit or pass any law impairing the obligation of contracts, yet the Congress themselves are under no constitutional restraints on these points. Golly, doesn't that sound familiar? Just print more money. Oh, we're in debt? Just print more money. Just print more money. 12. The number of representatives which shall compose the principal branch of Congress is so small as to occasion general complaint. Congress, however, have no power to increase the number of representatives, but may reduce it even to 1/5 part of the present arrangement. 13th. On the other hand, no state can call forth its militia even to suppress any insurrection or domestic violence which may take place among its own citizens. This power is, by the Constitution, vested in Congress. Article 4, Section 4. 14. No state can compel one of its own citizens to pay a debt due to a citizen of a neighboring state. Thus, a Jersey man will be unable to recover the price of a turkey sold in the Philadelphia market if the purchaser shall be inclined to dispute without commencing an action in one of the federal courts. 15. No state can encourage its own manufacturers either by prohibiting or even laying a duty on the importation of foreign articles. In 16, no state can give relief to insolvent debtors, however distressing their situation may be, since Congress will have the exclusive right of establishing uniform laws on the subject of bankruptcies throughout the United States, and the particular states are expressly prohibited from passing any law impairing the obligation of contracts. Signed, the Deliberator. Excellent. So if you have any questions about what was said in number 44, maybe questions about what was said in the preceding papers, or there's a legal topic you'd like me to cover in a future lecture, go ahead and post those down in the comments, because the entire purpose of the Calhoun School of Law is to provide you with the necessary skills and information to combat any sort of lawfare that will be waged against you, your loved ones, or your hard-earned property. So please, if you have any questions at all, go ahead and post them down in the comments. Excellent. So my name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information that plenty of bad folks would rather not have. I hope you enjoyed this lecture, and if not, while you're down in the comments, go ahead and let me know how I can do better so I can best serve that purpose of helping you. I hope you'll have a wonderful day, and I'm not sure what the topic for the next lecture is going to be, but I'll do my best to make it as informative and entertaining as this one, if not more so. Regardless of the topic of the next lecture, until I see y'all then, I bid you all farewell.